Hi, and welcome back to this Thursday edition of Focal Point on AFR Talk. Especially if you live in the state of Texas, I'd like to hear from you. We've got a pretty good footprint in the state of Texas. I'm not going to restrict phone calls to people from Texas. Don't misunderstand me, but this is your state. And a judge has just messed with you. A judge has just tyrannically imposed his will on you. He has imposed the recognition of sexual deviancy in your state. A judge has imposed the recognition of the infamous crime against nature as something that ought to not be condemned by society, but ought to be supported and extolled and celebrated and commemorated and solemnized by society. I want to know how you feel about that. And I want to know what you want Governor Perry to do. Now, I'm suggesting something that I actually do not think is radical whatsoever. People will say it's radical, but I don't believe it is. Because you have the Constitution being flouted, the Constitution being violated, and it's important to have somebody that steps up to the plate and says, look, I'm going to do the constitutional thing here. I took an oath to uphold and defend the Constitution of the United States. I did not take an oath to uphold and defend the rulings of Judge Orlando Garcia. I never made one single solitary oath to uphold the rulings of Judge Orlando Garcia. I am under no obligation by the laws of the state of Texas, by the Constitution of the state of Texas, or by the Constitution of the United States of America to meekly submit to a blatantly unconstitutional ruling and directive. And I tell you, ladies and gentlemen, we have been doing this since 1963. Remember 1963, the Supreme Court said you can't pray in schools. We meekly complied. 1964, the Supreme Court said you can't read the Bible in public schools. We meekly submitted and capitulated. 1980, the Supreme Court said you can't put the Ten Commandments on schoolhouse walls. We submitted. One after another, these rights, unconstitutional rulings. 1973, Supreme Court said you can't have laws restricting abortion. We meekly complied. 2003, Supreme Court said you cannot criminalize homosexual behavior. We meekly complied. And I say we got to come to a point in our culture where we just stop surrendering, capitulating weakly and in timidity to these unconstitutional rulings. Now, I want to be clear about this. I'm only saying this because my regard is for the Constitution. I have no regard, I have no respect for a ruling issued by a judge that is at variance and in violation of the Constitution of the United States. And that's why we need public leaders with the courage, with enough titanium in their spines to actually defend and uphold the Constitution. And I think what Governor Perry could do here is he could remind the federal judiciary, look, the first three words in the Constitution are we the people. Not we, the black-robed tyrants, but we the people. So I think he has an opportunity to do it. I'd like to know what you think. I'm happy to hear from anybody across the fruited plain, not just from the state of Texas, but I'm particularly interested in hearing from people in the state of Texas about what you think. And do you want Governor Perry to do what I have suggested? Do you want Governor Perry simply to refuse to submit to this unconstitutional ruling and just simply issue an edict to all county clerks? Look, it's against the law of the state of Texas. It's against the Constitution of the state of Texas to issue even one single solitary wedding license, marriage license, to a same-sex couple. We are not going to do it in Texas because I took an oath to uphold the Constitution of the state of Texas, and I am going to do it. I want to know what you think about that if you'd like to see the governor do that. Because I'm telling you, ladies and gentlemen, this could be the start of a reversal on all this. If Governor Perry will do this, this could be a momentous moment in American history. This could be a hinge point in American history. American history could begin to turn from darkness and in the direction of light if we just have one governor with the courage to do what I'm talking about, and perhaps Governor Perry may be it. The number to call if you want to weigh in, 888-589-8840, 888-589-8840. Now, let's go to clip 4, Rob. I've got several clips from Jonathan Turley. He's teaches law at George Washington University. He's a hardcore liberal. This guy's an uber leftist. In fact, he says in these sound bites, look, I agree with Obama about everything. I just think he's going about things in the wrong way by ignoring the checks and balances in the Constitution. Here is Jonathan Turley clip 4 last night on Megyn Kelly. Remember, Eric Holder told attorneys general all across the United States, you don't have to defend the marriage law. If you don't like it, you don't have to defend it. Just let it drop. Don't show up. Don't defend it. And Jonathan Turley here, this guy's an uber left-winger. He agrees with Eric Holder about gay marriage. He agrees with Barack Obama about gay marriage, but he says, look, this is not the way you go about it. Let's listen.
That's right. And what people need to remember is that attorney generals assert the absolute right to be the sole defender of these laws. So when they leave, when they are sort of absent without leave, there's no one there. I felt what Holder's mistake was, and this is why I think his advice was bad today, is that he didn't create a substitute, somebody that would guarantee a full and fair hearing. He was just saying, pull the ladder up behind you. Mm-hmm. And that's a serious problem for the separation of powers. DOMA was duly enacted by Congress and signed by Bill Clinton. And this is a problem that Congress is facing. I'll be testifying tomorrow at the same hearing as the congressman. And this is one of the issues we're going to have to deal with, because it is a serious problem when someone says, I alone can defend statutes as the representative of the United States, and then he's just not there to do it.
So that's a pretty profound observation. We talked about this before, but if you don't defend your goal line, the other team is going to score. You are conceding defeat. And that's what Eric Holder is saying to these attorneys general. Just give up. Just don't even try to defend the goal line. Even though you took a solemn oath to do it, don't do it. That's my advice to you, and it's absolutely inexcusable. Now, Jonathan Turley giving testimony yesterday before a congressional hearing, and 3 sound bites here. But again, he talks, and the third one will get really to the point where he talks about what a dangerous place we are in. Jonathan Turley has given testimony before where he has said to lawmakers in Congress, look, we're witnessing something unprecedented. We have never seen a president do to the Constitution what this president is doing. Anyway, here's Jonathan Turley, 3 clips. Clip 1 from his testimony yesterday on Capitol Hill.
But the rate at which executive power is being concentrated in our system is accelerating. And frankly, I am very alarmed by the implications of that aggregation of power. What also alarms me, however, is that the 2 other branches appear not just simply passive but inert in the face of this concentration of authority.
So that is Jonathan Turley, and that's pretty alarming. I mean, that's pretty sobering what he says. He says, I'm alarmed. I'm alarmed at what this president is doing. And part of what alarms me is the way in which the concentration of power in the executive branch is accelerating. In other words, he says, we are heading downhill. There's a ravine at the bottom. There are boulders at the bottom. And we're heading straight down to the bottom of this ravine, and the pace is quickening. And he's alarmed. He's a liberal who is alarmed at what President Obama is doing. Here is clip number 2, Jonathan Turley looking for a place to level the blame, and here's who he picks.
Indeed, the branch that I blame the most for the problems we're having is the branch that's rarely mentioned, and that is the judicial branch. It was once referred to as the least dangerous branch, but has made itself into the least relevant branch after Raines and other cases. Specifically, it has created barriers for member standing or legislative standing, which I think is key if we're going to rebalance this system. What is strange is that the Supreme Court has dealt with this by saying they're defending separation of powers by refusing to reinforce it. It's like a fire department refusing to put out fires because only you can prevent fires. They are tasked with the job of maintaining the separation of powers.
Now, what he's talking about here, and he's exactly right, the founders thought the judiciary was the least dangerous, the least powerful of all the branches of government, and it was intentionally designed to be that way. In fact, the scope of the Supreme Court was so limited that they met in a closet in the first Capitol. So that's how little influence and power the founders had given to the Supreme Court. Remember, the Supreme Court's role originally, you look at the Constitution, the only thing that it's given jurisdiction over basically, anything that has to do with international affairs, where the United States government is officially an actor, but when it came to domestic cases, the only place for the Supreme Court was in dealing with conflicts between states that could not get resolved. You know, if you've got a Supreme Court of Missouri says this is fine, and Kansas has got a quarrel with the state of Missouri, and their Supreme Court says, we think what we're doing here is fine, and it has to do with the conflict between the two states, somebody's got to resolve that. That's the role of the Supreme Court, and that is it. That was the only role that it was assigned by the founders. And what Jonathan Turley's talking about here is the Supreme Court has taken away from Congress what's called standing. That's the right to bring a lawsuit. Congress right now doesn't have the right to bring a lawsuit against an overreach by the president. So they can't even go to court and say, look, the executive branch has overstepped the boundaries of Congress, and that's because of the Supreme Court tying their hands. Here is clip number 3.
I do want to emphasize one thing, however, in closing. This common article of faith that we have in our system has served us well. The short-term insular victories that are achieved in this term will come with prohibitive cost. I happen to agree with many of those policies, but I do not agree with the means. I believe we are now at a constitutional tipping point in our system. It's a dangerous point for our system to be in, and I believe that your response has to begin before this president leaves office.
So he says, look, we are at a constitutional tipping point. I mean, that's pretty alarming when you think about it. He says, I do not approve of the way in which this president is going about doing his business. There is going to be a prohibitive cost to what this president is doing. And I don't know if you caught that at the end, but that's very, he says, look, we have got to start taking corrective action before this president leaves office. Did you get that? That is a liberal law professor, agrees with Obama's agenda 100%, but he says we are in crisis as a country. We're in a constitutional crisis. We're in a political crisis because we have a president that is out of control, that is ignoring the separation of powers, ignoring the limits that are established by the Constitution, and we have got to do something about it before he leaves office. He says we cannot even wait to elect a new president. We've got to do something. We've got to do something now. I think Governor Perry could be the guy that starts that. We'll take your phone calls right after the break, 888-589-8840.